memos from... I'm sorry. Ms. Rowan, I was asking you before the break about said that those memos were presented to the sisters at a meeting at the end of 1998. Now, is it the case that the majority of the congregation at that time supported, firstly, the giving of the apology?
Yes.
And secondly, the settlement of the legal claims on the basis of Mr Hancock's advice?
It wasn't just the majority, it was an overwhelming response. Any of the sisters who could be at that meeting were wholehearted in their support of the response.
And when the time came to sell Neerkol, were the sisters overwhelmingly in favour of that as well?
Yes.
And was there some sense of not only selling Neerkol to fund the amounts payable to the residents, but also of the rightness of selling Neerkol?
Yes, it was the most appropriate way to respond.
And are the sisters, or were the sisters in your time, supportive of the work done by the Professional Standards Committee and the ongoing support of the residents?
They were very, very grateful for that work.
Now, turning now to the relationship between the sisters, the diocese and the action group, you will have heard some questions and had some questions yourself about the role of the Bishop Heenan at the time, in the Neerkol Action Support Group. Now, firstly, you said you recalled that once you approached the Action Group, they were of the view that they would work things out with you first and then move on to the diocese. Is that correct? Now, if you can look at tab 127. And if that could come up on the screen. Is this a note from Mr Bowman, who's the financial director of the sisters? And is it an account of the meeting of the 18th of June?
A record that Mr Bowman compiled for my information, yes.
And if we can just stop with paragraph 2 on the screen, you'll see that there was an account of the outcomes of that meeting. The first one was that the meeting contents were to be kept confidential and to be without prejudice. No more comments to the media, and that you would provide $5,000 to the victims of crime in Queensland. Was that something that you were asked for, or did you offer it?
It was asked for. They were supporting residents who were going to give testimony at hearings, and we wanted to be able to support them in that.
And that was the hearings of the Ford inquiry? No, I'm sorry.
That was the criminal cases.
The criminal cases, I'm sorry. And so that was support for the victims in another way. And then there's the question of the payment of the activities of the Neerkol Action Support Group. And again, was that something you were very happy to do?
Yes.
Now, the next one is the question of the apology, and it's this dot point that I'd like to take you to. You see that the note was that the question of apologies were to be the subject of further consideration, public, private, by whom, to whom. And then it says, strong suggestion that the apology by Diane on behalf of the sisters is not enough. Apology may be needed from higher or Catholic hierarchy, bishop or archbishop. And do you have a comment in relation to that recollection of Mr Baumann as to the level of involvement by the diocese at that point?
The diocese hadn't been involved at this point in the work with the Neerkol Action Support Group, but they expressed that view at the meeting.
And that at some point, once the apology had been worked out with you, but they would then approach the bishop. And of course, the bishop's apology, the bishop, once he had attended one of the meetings, adopted the sentiments in your apology and then issued his own. And were you present at the meetings where the Bishop and the members of the action group worked through the terms of his apology?
Yes.
Was that a similar process to what you had undertaken with the members of the action group?
At the first meeting with the Bishop and the Neerkol Action Support Group, they communicated some of the ways that they had been hurt, especially by the Bishop's earlier statements, and he recognised that in drafting his apology to them.
And again, they were given the opportunity and took it to express themselves in relation to the apology. And did you take the view, on a personal level of course, whether those comments had been taken into account by the Bishop in his final apology?
I believe the Bishop certainly listened very carefully to what they said.
Now, you were asked some questions about the sale of Neerkol and the amount that you received, and you were shown a document, I think, a transfer from the Corporation of Sisters of Mercy to the purchaser, and a purchase price of $1.43 million. And you said your recollection was it was $1.3 million. Do you recall whether there was GST on the sale?
There was, yes.
And would the 1.43 reflect the payment of GST on the sale price of 1.3 million?
Yes. There would have also been agents' fees that would have been deducted from that amount as well.
The payment of GST on the sale price of 1.3 million?
Yes. There would have also been...
I've said, I think, to the Commission that the whole of the sale after repayment of the loan taken out to fund compensation to date has been expended, as far as you're aware, during your time, on the maintenance of the Professional Standards Office.
Yes, the response of those who were at Neerkol, my memory, which is not great, from Sister Bernice's feedback, was something like 1.2 million had been spent since 1996.
So it's more than the proceeds of sale has been expended.
Yes.
And it certainly doesn't just go on the salaries and the running of the office, it goes on direct support to the residents. And perhaps while I'm on that topic, were you here for Sister Bernice's evidence?
I was.
When I ran through the kinds of support that were given to residents, were those kind of supports, you recall, counselling, medical assistance and various other supports given to residents or provided to residents in your day?
Yes, most definitely.
And there's a note in your one of your notes that yoga groups were one of the other needs that people felt they needed.
Because the impact of the trauma and all that had happened to them was so devastating, I think the sisters were prepared to support any initiatives that would be of assistance. And again, as Sister Bernice said, it was different for different people, and it could be different at different times. Counselling sort of seems like a good starting place, but as time goes on, other things would seem to be more appropriate and more needed at that moment.
And the funds that were paid as settlement of the class action were paid out to those residents, but the balance of the funding and the services of the Professional Standards Office are available to those residents or any others who come forward. So the monies left over, if you like, from the settlement, from the sale of Neerkol, have been used not for a specific group of people, but for anyone who could come to you.
Anyone who was at Neerkol.
And was there a cap in your time as leader on provision to any particular person? Was there any sort of sub-caps of categories of expenditure that they needed to fulfil? For example, did they get a certain amount for counselling or a certain amount for something else?
The counselling was usually done in amounts to say, well, whether it was 1,000 or 10 sessions, and then reviewed at the end of that time. If the person indicated it was helpful, then it was continued.
And indeed, some people have continued for many years, as you understand it.
It's true.
Now, you asked some questions about the investigation process or the assessment process through towards healing and the involvement of Mr O'Brien. Now, he was a former policeman, is that right?
I believe so.
And he was an investigator with the police?
He was, I believe, yes.
And did you know that he had been involved with child sexual abuse cases in the Queensland Police? Was that one of the factors you looked at when choosing him?
I don't remember.
But it's likely, is it not, that the Queensland Police would have had some training for their officers in dealing with people who had suffered sexual abuse as a child. And if that was so, he would have had the benefit of that training
Yes.
when he worked for you.
Yes.
And you took the view that there would be no more assessments, effectively, because you understood the allegations to be true and you accepted them. And
I don't want to appear critical of his work and what he did do. It was really the impact on the residents and the reality of having to retell their story and be questioned. That was the reason we made that decision.
so there wasn't a complaint.
The reality of having to retell their story and be questioned, that was the reason.
In itself.
Yes.
So that you don't mean to be at all critical of the way in which that was conducted.
Yes.
Now, you were asked about the contact you had with the sisters in relation to face-to-face apologies and the way in which the nuns who were still alive were dealt with. Now, you've agreed that, as you understood it, there were no nuns alive who had been alleged to have sexually assaulted any of the former residents when you made that inquiry.
Yes.
Did that remain the case? Did you ever become aware of a nun who had been accused of sexual assault and who was still alive?
I didn't.
And did that... you had a number of gatherings with the sisters to discuss the allegations with them.
We did, yes.
And that was, I think there were 2 occasions in which you gave people the option of attending either occasion. And what were the kind of things that you discussed with the sisters at that point?
They were useful gatherings to try to hear from them, their experience, to try to understand why these sorts of allegations, what was their experience like at Neerkol.
And from those gatherings, were you left in any doubt that there were, I withdraw that, from those gatherings and from your other knowledge of the way Neerkol was conducted, were you left in any doubt that allegations of physical abuse by children was likely to be true?
No, I was convinced it was true.
Now, you also spoke of face-to-face apologies. If we could have...
Just perhaps before you move on to that, Ms Needham, just really the second part of your question to Ms Rowan was, the second part of the answer that you gave, Ms Rowan, about your discussion about why these sorts of allegations or details of experience from the residents arose about the level of physical punishment that was going on at Neerkol. Was that productive of any further information for you to help you understand?
It certainly did help because it's hard to imagine in the present, looking back to what happened in those years. Quite an education for me to hear the conditions for both the residents, those who were children there, and for the sisters. It was really quite impossible to imagine, really, that this was in people's lifetimes, that they had to work in such difficult situations.
In terms, though, of helping you understand why and the type of culture that existed at the time and why that was allowed to happen, Did you gain any insight into that? Other than, I mean, you're obviously referring to the harshness of the conditions generally in terms of consistent with the findings of the Ford inquiry, underfunding and under-resourcing.
In terms of the discipline that was
Yes.
practiced, my impressions was that with large numbers of children and small numbers of staff, you needed this regime of discipline, and where there was lots of orders, lots of ways of behaving, lots of rules and regulations, there also needed to be consequences for people that did not keep the rules or did not obey. I think there must have been a series of levels of discipline, and corporal punishment was seen as quite acceptable, that if you overstepped the mark in this area, if that particular punishment didn't have the desired result, then there needed to be another level of discipline or action taken, which, again, I think was very regrettable. And I don't have the answers as to why it happened, but that's...
An explanation.
Yes.
Yeah.
Thank you. Now, you asked some questions about apologies from sisters, and could the document at CTJH 202-02027-0132R please be brought up? Now, Sister, you heard Sister Bernice, sorry, Ms. Rowan, you heard Sister Bernice give evidence about seeing Sister Frances Regis and talking to her in relation to AYP's complaints. Do you recall that evidence that she gave?
I do.
And is it the case that your position taken that any apology, face-to-face meetings for apology would need to be beneficial for both sides of the equation? Was that I think you said that was not a closed door. You'd be happy to look at things on a one-by-one basis. Mm-hmm. Now, can you have a look at this letter, please? Were you aware of this letter? It's a letter to AYP, August 98, from Sister Frances Regis.
I remember it now, yes.
Did you have anything to do with the provision of that apology from Sister Frances Regis to AYP?
Certainly I was part of the negotiations for that, yes.
And do you recall approaching AYP for the provision of that apology? Sorry, not AYP, Sister Frances Regis for the provision of that apology? And that was something that you were able to do for AYP to assist her with her healing?
Yes, she was... it was hoped that this would be of some assistance because she was unable to travel to meet with her in person.
And I think she was quite elderly at that point. And she provided that apology freely. You didn't direct her under the vow of obedience to do so. No. Thank you. Now, excuse me one moment. Excuse me. Ms. Rowan, you are no longer a member of the Sisters of Mercy, and you've said in your statement you left in 2003 after your leadership period finalised of the Sisters of Mercy. And you've said in your statement you left in 2003 after your the Neerkol complaints or allegations or experiences at all?
No.
You don't need to give the reasons if they're personal, but it didn't have anything to do with this, did it?
No. Working with those who had been at Neerkol was perhaps one of the hardest things I'd had to do, and with the media as well. But I would still consider it the greatest privilege to have been part of that, to meet them and to work with them. And
I think you've said in your statement that you've welcomed the work of the Royal Commission, and you've also mentioned in your statement the important work done by the current professional standards coordinators and past. Would you be able to tell the Commission the importance of the work that they do with the residents?
Most definitely, thank you. Because the residents were very nervous about dealing with sisters, we were really very fortunate to have wonderful professionals like Sue Prosser, like Joe Menziger, Jenny Casey stepped in for a while as one of them, as well as Margie Newton was the one. I'm sorry, that's terrible. Margie Newton was another one who acted that role, and then Anne Chikansky. And for someone like Anne it's ridiculous. Someone like Anne to continue in this role for 17 years or so is just a wonderful testament to her. She was very, very professional and very, very compassionate. And the Sisters of Mercy, I think, owe her a tremendous debt for what she has done. I want to know this. I'm so sorry. I must be just tired.
Would you like a glass? Just take a sip of water and take a deep breath. Thank you.
Now, should I get that right? Sorry.
Yes, thank you for that. And in your time, the response coordinators were the first line of approach, and they, as Ms David asked you, had quite a lot of leeway about how they responded to complaints without having to revert to you, and they also had the ability to provide that support without necessarily any indication of to whom that support was given through the books. Is that right?
That's true.
And did you see those things as very important?
I do. It was really to try to treat each person with dignity and respect.
Now, you said that the experience of working with the Neerkol survivors was one of the hardest things, but also a privilege. Is there anyone in particular that your journey through this has been particularly assisted by?
I would really like to pay tribute to the Neerkol Action Support Group. Their chairman, AYD, had such a difficult experience himself. To become a man of such integrity, courage, a man who is such a gentleman and so caring of others, I understand how distressing it was to revisit his experiences at Neerkol and its impact, and yet to put that aside and to work for the sake of the other Neerkol residents, I think is just inspiring. Mary Adams, as their secretary, put in an enormous amount of hours of work to make this committee work. So I think they really, and I know there's lots of people in the background. Alan Alloway, I think, decided he was going to be the media spokesperson for the Neerkol Action Support Group and did it with dramatic effect, I would suggest. But there are many that I couldn't possibly name, some who are deceased now, but they were wonderful advocates for all the residents. So I would like to thank them.
And this has been, Sister Bernice and Bishop Heenan have each agreed that it was a learning experience for them. It was a learning experience for you too?
Oh, definitely. It's crazy to think that you'd choose a teacher from Blackall to be the leader of a congregation when you're the fourth youngest member of that congregation at the time. And you'd say to them, let's see what you can do in this situation. I'm very, very grateful for their help, their prayers, their support, their guidance.
And is there anything else you'd like to say to the witnesses who have given evidence? You've heard their stories and their pain, and you've been there on their journey. Is there anything you'd like to say to them?
Thank you. I really would like to thank them for their courage. I had read many accounts of the experiences at Neerkol. But when you actually hear their accounts, it makes such a difference. I know that they had shared their accounts at the Ford inquiry, but most of that was in private hearings and private sessions. To do this publicly, knowing that it is quite traumatic, quite difficult, I really do want to thank them for their courage. It has been wonderful to meet them again after all these years. I mean, apart from a few Christmas cards and ongoing communication. I'm so sorry. It has been wonderful. To be treated with such compassion and such respect. I've been inspired by them and I would like to thank them. Wish I could do it better though.
Thank you. I have no further questions unless there's anything else you'd like to say. Ms. Rowan.
Is there something else you'd like to say, Ms. Rowan?
I repeat again, it was a real privilege to be part of this. And I do want to thank the Royal Commission for the wonderful work you're doing. Despite our failings, I genuinely believe this will be helpful into the future. So I would like to thank you very much.
Thank you, Ms. Rowan.
Ms. Rowan, perhaps just following on from that.
Yes.
Can I just invite you to perhaps give us your reflections on what I think you have described, not in as many words, but in effect in the contents of the apology, which was a journey from, I think your words were in the apology, scepticism and disbelief, to where the sisters got to, say, by early 1997. So what I'm asking you to do is to give us your reflections on what you think were the important features that allowed for that developing understanding as you've described in your apology to happen.
Thank you. It made such a difference to actually meet people and to listen to them and to listen to their experiences. I was one of those people that joined. I was at boarding school at 15. I'd had no experience of sexual abuse in any family or any story. I really didn't understand it. It was so foreign to me. So that to have people who had the courage, who were willing to make themselves vulnerable and to share their accounts, that made a really big difference. And I think hearing from them really changed my life, and to learn from them just the long-term effects of what had happened in their childhood.
Thank you. In the contents of the apology, though, you use the language of scepticism and disbelief, so it's more than just a lack of knowledge. That describes something more active, doesn't it?
That's true.
And I assume that you were describing a culture or an attitude inside the congregation before that exposure. Is that so?
Yes. And I think it's true even in society. Whenever people talk about allegations of abuse, the first thing many people seem to say is, oh, they just want money, they just want compensation, they want to sue somebody. And it takes a lot to challenge people to believe that this actually happened. I think even I've been a bit distressed by some people who've listened to, evidence in lots of and say that couldn't possibly have happened. And you think it's more than just in the sisters. I think it's a widespread belief, and to understand maybe how this would have seemed to children. Sometimes what they saw or imagined that had happened wasn't accurate. I think the Ford inquiry helped to sort of highlight some of those misunderstandings. But it's easy to understand when you're a child and someone is not there anymore. You begin to imagine what happened to them and why don't we know where they were when they were a part of their story? So does that also help?
So I do understand what you're saying is that what you would isolate as the single most important feature that moved you, and I think you're also saying the congregation, from scepticism and disbelief to acceptance and understanding, was actually meeting the people who recounted their life experience to you.
That's right.
Thank you.
Just following that line of questioning briefly, please, Ms. Rowan. When you were leader of the congregation and you were dealing with these issues with your fellow sisters, your congregation, did they come to a realization that decades of cruelty exposed at Neerkol was not just shameful, but was thoroughly unchristian?
Yes. There is a line in Christianity, or perhaps in some religions, which says, no, well, even in sport, isn't it? They say no pain, no gain. That sense that, sometimes hard things, you have to do hard things and your reward will be great. So there is this little bit of a line which says, well, if you suffer, it will be good for you. I don't think anyone agrees with that today, but it was it was an element.
Well, the suffering was all by the children, wasn't it?
The sisters did suffer too. I know it does not excuse what happened with the children, but I do know from listening to the sisters how they also suffered.
Any re-examination?
Your Honour, I'm sorry. There was a document that was provided over lunch, and it just raises two questions for me of this witness.
Yes.
I apologise to Ms. Needham. Ms. Rowan, my name is Kernigan, as you know, and I asked for Margaret Campbell, and I have some questions about her interests.
Sure.
Could the document QLD 0062 001 0348_R be put on the screen? It's not ready. Right. I'm sorry, I understand that document's not ready to be put on the screen. I'll ask you about an event which happened at about the time that I understand you were leaving the congregation as its leader. Am I right in saying that happened in 2001?
I finished as the leader in December 2001.
And you took on a new role vis-à-vis education after that for some period of time.
I finished as the leader in December 2001.
And you took on a new role of the police investigation and prosecutions of Mr. Kevin Baker.
Yes.
And during that period of time, were you aware of any role provided by the Sisters of Mercy towards the complainants in those cases?
I'm not sure what you mean.
Were you aware of anyone from the Sisters of Mercy were providing support for the complainants through the criminal process?
I believe from looking at the documents for the Royal Commission that were in the tender bundle that some sisters might have been called as character witnesses, or if that's the terminology.
Were you aware of anyone from the Sisters of Mercy actually contacting the DPP on behalf of a complainant to indicate that that complainant didn't want to proceed with the charges?
Someone from the Sisters of Mercy?
Yes.
I'm not aware of that, no.
Ms Anne Chikansky, would you have been aware if she had contacted, or are you aware that she reportedly contacted the Queensland DPP to advise them that a complainant that she was providing support for did not wish to proceed with a prosecution of Mr Baker?
I'm not aware of that happening, but I can only presume it would have been on the advice of the person.
So at the time that you were in a position to have knowledge over the Baker prosecution, was there any policy within the Sisters of Mercy to provide active witness support for complainants in the charges against him?
I couldn't say for sure. I thought that we were offering support through victims of crime or from other requests for assistance.
Such as for counsellors
and
meeting costs
yes.
involved in that?
Yes.
But there was never any concerted effort, at least from a leadership level, so far as you're aware, of actually providing direct support between Sisters of Mercy and the complainants during those criminal trials?
I don't think so. I'm not exactly sure, though.
And lastly, is it correct to say that by 2002, I'm sorry, I'll withdraw that, Your Honour. Those are my questions. Thank you.
Thanks, Mr Konigan. Anything arising out of that for you, Ms Needham? No. And nothing for you either?
There's nothing arising.
Mr David. Thank you, Ms Rowan. Thank you for your attendance, and you're otherwise excused.
Thank you very much.
It's excused.
Thank you very much.
98, a letter to AYP from Sister Frances Regis.
26.33.
And can I also tender a second document referred to by Ms Needham with the identification number of CTJH 202 08005 0105 relating to some notes made, as I recall, by Ms Rowan.
26.34.
I call Mr Daniel Boyle.
I've been instructed to tender a further statement by my client. That was provided to the solicitor instructing senior counsel assisting earlier in the week, and I understand it's now been appropriately redacted. I understand there are copies of that being made, or have been made.
You had the opportunity to have a look at that.
I have. I looked at that, but not the redacted copy. I don't have any opposition to it being tendered. It's a statement of AYN dated the 20th of April 2015.
26.35.
Give the transfer which I provided to...
Can't hear you,
I'm
Ms
sorry.
McGlinchey.
Commissioner, can I ask if the transfer of for the sale of land of Neerkol has been tendered?
Are you asking if it has been tendered? I think it's in the tender bundle, isn't it?
It's not, Your Honour.
Would you like it? Yes, please.
I tender the transfer dated the 24th of January 2001.
Sorry, I thought it had been referred to as...
It was referred to, but it wasn't in the
It wasn't in the tender bundle, so it would be now marked as, tendered and marked as 26.36. Now, ready to proceed with Mr Boyle. Mr Boyle, do you wish to take the oath or the affirmation?
The oath. Thank you.
So could you repeat after me, please? I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
the evidence I shall give
in this Royal Commission
in this Royal Commission
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the
and
truth.
nothing but the truth.
Thank you, Mr Boyle. Replace the Bible and take a seat, please.
Mr Boyle, you are an in-house counsel for the Office of the Director of Public Prosecutions, Queensland.
That's correct.
You were admitted in 1987.
87 as a solicitor and December 1988 as a barrister.
You worked for 5 years at the Office of the DPP from late 1987, is that correct?
That's correct.
Then 5 years at the Commonwealth DPP.
That's correct.
Then 5 years at the Independent Bar.
That's correct.
And then you spent 6 years at the Crime and Misconduct Commission, as it was then known, of Queensland.
Correct.
And 6 years with the state DPP again.
Yes, as in my current position as consultant Crown prosecutor.
And throughout that long career, you have prosecuted numerous child sexual offences.
I have.
And you've had conduct of numerous child sexual matters.
That's true.
You've provided 2 statements to the Royal Commission. The first dated the 26th of March 2015.
I have.
And a supplementary statement dated the 17th of April 2015.
That's correct.
Both those statements relate to the prosecutions by the Queensland DPP of Father Reginald Durham and Mr Kevin Baker.
That's correct.
And you were not personally involved in those prosecutions, but you have been asked to review and consider the DPP files and also the court records in relation to those prosecutions.
That's correct, and I've done that.
I tender both statements, Your Honour.
Both statements as Exhibit 26.37.
Mr Boyle, in your first statement of the 26th of March of this year, you set out the progress of the criminal proceedings against firstly Father Reginald Durham and secondly Mr Kevin Baker.
That's correct.
And firstly, generally speaking, both those prosecutions related primarily to complaints made by former residents of Neerkol alleging sexual offending by firstly Father Durham and secondly Mr Baker.
That's true. I think there might have been one exception, not being involved with Neerkol, and I think that was AYB.
Yes. I'll take you to the main features of your statements. Primarily, my questions of you are in respect of the law as it existed in Queensland when those prosecutions were taking place, the law as it related to child sexual offences, and how that has changed and improved at the present time. But to do that, I need to take you to some main features of the progress of those criminal proceedings.
I understand.
So if I can ask you to start at paragraph 7 of your statement. On the 6th of February 1997, there was a complaint and summons, which is essentially a charge sheet that brings an accused person to the court, alleging 40 sexual offences against Father Durham. That's correct?
That's true.
Those 40 charges related to 6 complainants?
Yes.
And 5 of those complainants were former residents of Neerkol?
That's true.
And one of those complainants was AYB, who had had contact with Father Durham before or when he was resident at the presbytery at Neerkol.
I understand that's correct.
Those charges progressed through the courts, through committal proceedings, and Father Durham was indicted before the district court on those charges. And if I can take you to paragraph 23 of your statement. In respect of AYB, on the 24th of July 1998, paragraph 21. Firstly, in respect of AYB, there was an 18-count indictment presented to the district court on the 2nd of February 1998.
That's true.
And then on the, if we stay with AYB, there was an unsuccessful application for a stay of proceedings in respect of the charges relating to AYB.
Yes.
And then ultimately, the DPP produced or presented a new indictment which reduced the charges to 6 counts of indecently dealing with AYB.
That's correct.
And Father Durham pleaded to those 6 counts.
He did.
And on the 15th of February 1999, he was sentenced to 18 months imprisonment with a recommendation that he be released after serving 4 months.
Or considered for parole after serving 4 months, yes.
You say in your statement that part of the reason the DPP decided to reduce the charges and accept the plea to the reduced charges was because there was a difficulty with particulars?
Yes, that was one of the issues.
And particulars, or lack of particulars, relates to a situation where there is one charge on an information, but there are numerous acts or acts of offending which could form the basis of that charge.
That's right, and the need to identify a particular act or event for the purpose of running a criminal prosecution.
And with matters that, or allegations which occurred many years ago, firstly, and secondly, allegations made by young children or adults about events when they were a child, it's common, isn't it, for those persons not to be able to identify with a lot of particularity the date, the time, the occasion that the alleged offending is said to occur.
Certainly from experience, even though children can give convincing evidence as to what has occurred, where there has been a number of acts and a relationship between the complainant and the accused, it's difficult to distinguish for the purpose of particulars to run a prosecution. There has to be some form of objective external facts or events or circumstances. It doesn't necessarily mean there has to be a precise date, but there has to be something identifiable for the purpose of a criminal prosecution. So, yes, there are difficulties with historical matters and with children being able to give that information with sufficient particularity to meet the test, the common law test on particulars.
So, for example, a person will often be able to say, when I was a child, the alleged offender had sex with me many times. He had sex with me in a particular way, that is, vaginal sexual intercourse or indecently touched me, but I can't tell you about one occasion as opposed to another occasion, just that it happened all the time. And in that way, a person's allegations will not be sufficiently particular for the matter to proceed under the legislation as it would have existed before recent amendments.
That's correct. The difficulty is where the child is unable to distinguish details of one act from many others. So the scenario you've just given is an example of a case where there wouldn't be able to be sufficient particulars to run a prosecution.
So while you may accept everything that a person says is true, it might bear no reflection on their honesty or veracity. It just might be that the evidence that they would give is not sufficiently particular for the matter to proceed to a criminal prosecution.
That's right, and it's no reflection on the reliability of the witness. It's simply that they are unable to provide that level of detail to distinguish a particular occasion.
Now, in respect of Father Durham, putting AYB the allegations made by AYB to one side and the charges to which Father Durham ultimately pleaded guilty, the other 5 complainants, their charges were presented to the District Court on a separate indictment.
That's correct.
And at paragraph 31, you refer to the 22-count indictment, so the second 22-count indictment that was presented to the District Court in respect of Father Durham. That charged 22 offences in relation to 5 different complainants.
That's right.
And a decision was made by the Office of the DPP and the prosecutor who had conduct of the matter that separate trials should be had in respect of each complainant's charges.
That's correct. A memorandum was prepared by the trial prosecutor, which was then sent to the Deputy Director in Brisbane, and that decision was made.
Now that memorandum is found at Tender Bundle, the document found in Tender Bundle 244, and essentially the legal opinion of the prosecutor who considered the matter was that the evidence in respect of one complainant was not cross-admissible in respect of the other complainants.
That's so.
And so there was no legal justification for running all charges together in one trial.
Yes. Also dealing with the issue of there was a review of the cases, but in particular the cases of De Jesus and also Fennick, which sets the bar in terms of the admissibility of evidence, and really it was purely on the basis of consideration of those legal principles that this decision was made.
In making that decision, the prosecutor had reference to the relevant legislative provisions under the Queensland Code, and also the common law cases in respect of those provisions.
Yes.
And was of the view that the evidence to be given from one complainant was not cross-admissible in respect of the other, and given there was no cross-admissibility, there was unfair prejudice to the accused in having all charges heard together.
That's right. In terms of separate trials, particularly with sexual offences, that peculiarly likely to give rise to prejudice, there is dangers of the use of it as being mere propensity, and likely to give rise to prejudice. There is dangers of decisions made to run separate trials.
I'll come back to the law when we consider that decision shortly, but in essence, these legislative provisions and the relevant cases was considered by the prosecutor. An advice or a memorandum was written to the director or the representative for the director was considered by the prosecutor. An advice or a memorandum was written. You would agree that that significantly weakened the case against Father Durham? Or perhaps I'll put it a different way, it would have been a significantly stronger case against Father Durham if all charges were heard together.
I really do have to object, if it please the Commission. Characterisation of a case as being stronger when it would be contrary to legal principle to do so is not helpful to this Commission in our submission. One really should confine this discussion to the principles of law, which it seems to be accepted are properly guiding those on the ground at the time. One can invent all kinds of prejudicial evidence which would make something stronger. It doesn't help to discuss it in that way in our submission.
I'll rephrase it. If the legislative provisions allowed for the joinder of these charges, so the charges alleged by each complainant to be heard in one trial, that would allow for a significantly stronger prosecution against Father Durham. Would you agree with that?
It's difficult for me to answer that question. It's recognised that there's certain dangers involved in running trials because it goes to mere propensity of an accused to commit an indecent acts with children, and that he was more likely the sort of person to do that. So the potential for a conviction may be greater, but the issue is the lawful admissibility of the evidence and the use of that evidence in considering individual complainants.
I understand that. My question is, if the legislation, as it does in some states, allows for the joinder of all these charges together to be heard as one trial, it would make for a stronger case against Father Durham. Would you agree with that?
I don't know that I can necessarily agree, because that again would depend on the directions that are given as to the use of the evidence of the other child witnesses.
Well, if they're joined together, they would necessarily be able to be used as admissible against each other, wouldn't they?
Yes, but for what purpose?
To prove each charge.
Propensity. I accept the proposition that in front of a jury, the potential for them to find guilt, or the potential of that occurring is certainly greater if you run multiple defendants.
Yes.
Because, but there may be, that may be
You mean
on the basis...
multiple complainants, don't you?
Sorry, multiple complainants. Thank you, Your Honour. So it just... It's not an easy question to just say it's stronger, but there's a risk that the jury will form the view that where there's smoke there's fire, and that well, if he's guilty, he may be guilty of some of these, so we may convict him simply because of sheer numbers.
I'm not asking about that. I'm actually just asking you whether, if there are legislative provisions which allow for the prosecution of more than one complainant, it makes for a stronger Crown case. As a general principle, would you agree with that?
Look,
Perhaps to add, with a jury properly directed on impermissible reasoning. Mr. Boyle, does that assist you?
yes, I suppose that. I mean, in the end, I probably would accept it as a...
Okay, so in any event, on the law as it existed at the time this decision was taken, was that the charges against Father Durham should be tried separately.
That's correct.
And we have the advice that was given in respect to that at tab 244. We can see at paragraph 33 of your statement that a decision was made by the Office of the DPP to conduct the first trial in respect of the charges made by or alleged by AYP.
That's right.
And the basis for that decision was that the charges relating to AYP were the most serious in that she alleged a rape.
Correct.
Now, the first trial in respect to those charges resulted in a hung jury. That is, the jury were unable to come to, unable to agree on a decision.
That's true.
And they were discharged.
Correct.
And then there was a second trial or a retrial on those counts.
Yes.
That count. And in respect of the retrial, Father Durham was convicted.
Was.
And he was sentenced to 7.5 years. However, on appeal, the Court of Criminal Appeal in Queensland allowed an appeal against the conviction.
True. Quashed the conviction and ordered a retrial.
And the basis upon which that was done was the Court of Criminal Appeal found that the summary by the trial judge was unfairly weighted against the accused. There was a retrial ordered in respect of count 20 relating to AYP.
Yes.
But before that could occur, the Mental Health Review Tribunal found Father Durham unfit to stand trial.
That's so.
And on the basis of that finding, the DPP entered nolle prosequis in respect of all counts on that second indictment.
On the 23rd of March 2001.
And so all the charges in relation to the 5 complainants who made allegations against Father Durham were discontinued.
That's true.
So the two issues for the DPP and the courts in respect of the criminal proceedings against Father Durham were firstly the particulars, or the sufficiency of the particulars, and secondly, the severance of the charges. They were two issues that caused, that required your attention. in the prosecution of Father Durham.
Yes.
Now, can I just turn to the proceedings against Kevin Baker? And if we can turn to paragraph 48 of your statement. On the 31st of March 1998, Mr Baker was committed for trial on 69 offences, and they related to 12 complainants.
Yes.
And all of the complainants had been resident at Neerkol at some time during their childhood.
That's correct.
Not all of these charges were sexual offences. There was some assault occasioning harm offences, or the equivalent Queensland provision.
That's true.
If we can go down to paragraph 52. A 59-count indictment dated the 17th of August 1998 was presented in the District Court at Rockhampton.
Yes.
And that indictment related to the same 12 complainants.
That's correct.
And then at paragraph 54, again, a decision was made by the DPP to have separate trials in respect of the charges relating to each complainant, each of the 12 complainants.
Yes, that links back to the previous advice.
And the previous advice related to both Father Durham and Mr Baker,
True.
because there were similar considerations in respect of both. And again, that advice was prepared on the basis of the relevant legislative provisions and the fact that the DPP considered that the evidence was not cross-admissible and the accused would suffer prejudice if the matter ran as one trial.
That's correct.
And in respect of Mr Baker, the DPP decided to proceed in respect of AYR's complaints or charges first. And again, that was on the basis that they on their face were the most serious.
Yes.
There were numerous trials in respect to those charges. The first trial was conducted in the District Court between the 14th and the 20th of April 1999.
Yes.
Those charges. The first trial was conducted in the District Court between trial. The trial judge first ruled, at the end of the Crown case, ruled there was no case to answer in respect of 3 of the charges.
That's right, and he directed not guilty verdicts on those counts.
So he told the jury to find Mr Baker not guilty on the basis that there was insufficient particulars. There was no case to answer.
No case to answer.
So the complainants hadn't given evidence about the allegations which form the basis of those charges.
Yes.
And then in respect of the remaining 7 charges, Mr Baker was found not guilty of 3 and guilty of, and the jury were unable to agree or were hung on 4. Mr Baker was found not guilty of 3 and guilty of 4. There were 4 charges which remained to be tried.
Yes.
A new indictment was presented to the court in respect of those 4 counts.
Yes.
And that matter proceeded to trial in August 1999.
Yes, that's right.
And as it turned out, it proceeded to trial a bit early because one of the jurors from the previous trial was in fact the juror on this second trial.
Yes, which led to the discharge of that jury.
So that jury was discharged and the DPP had to start again.
A retrial was ordered.
And so if we go down to paragraph 63, the retrial was conducted in the District Court at Rockhampton from the 13th to the 16th of December 1999.
Yes.
And during this trial, the trial judge ruled that there was insufficient particulars in respect of 2 of the 4 counts.
That's true.
And following that ruling, a nolli prosequi against the other 2 counts.
Yes, that's true.
And following that ruling, a nolli prosequi.
Nolli prosequi was entered with respect to those counts which the ruling was made.
Oh, I'm sorry,
on
you're right.
particulars.
And the jury was discharged on the other counts.
That's right.
Ultimately, though, the DPP didn't on the other 2 counts.
No.
And was that because of the ruling that there was insufficient particulars on the 2 counts?
I think that is the case. I can't be sure whether I read there was a reason for that. I can't be sure in making a decision about the 2 counts that were nollied. So that was obviously deferred pending that decision being made.
Now, the ruling on a lack of particulars by the trial judge in the what turned out to be the 3rd trial. The particulars by the trial judge in the what turned out to referring that matter to the Attorney General to have a case stated in respect of that ruling, didn't they?
Yes, there was an initial advice shortly after that ruling, which went. There was an advice from the Deputy Director to the Director, who then referred the matter to the Attorney General, but at that stage there was no recommendation that there be a referral.
And the reason why there was no recommendation was that the DPP considered that the ruling was, in fact, correct, that the particulars that were provided in counts 2 and 3 as a matter of law were not sufficient for the matter to proceed to trial.
Yes, based on the fact that it was consistent with or appeared to be in line with what the law was at the time. That's the reason for the advice saying that it shouldn't be a matter of referral.
So, in relation to Mr Baker, the DPP then decided to prosecute the charges relating to a second alleged victim or complainant.
That's right.
And at paragraph 69, you set out that a 6-count indictment dated the 19th of June 2000 was then presented to the District Court.
Yes.
And that alleged 6 counts of indecent treatment of a boy under 14.
Correct.
And Mr Baker pleaded guilty.
Not guilty.
Oh, sorry, not guilty.
Yes.
And then after that, there was legal argument about the sufficiency of the particulars. And in effect, Mr Baker's counsel argued that the particulars were not sufficient for the matter to proceed to trial.
That's correct. That was the ruling.
And the trial judge agreed with that argument and ruled that the 6 counts was not sufficiently particularised.
Correct.
The DPP was invited to enter a nolli prosequi, and that's what the DPP did.
Yes.
Now, following that ruling, perhaps if I withdraw that, the basis upon which that ruling was made was that the complainant in that trial had alleged that the central incident, which formed the basis of the charges, was the first occasion anything had ever happened between the complainant and Mr Baker and the accused?
I'm not sure about that.
The complainant and Mr Baker and the accused.
Refers to the first occasion was in fact going back to the previous decision back made in December. That ultimately was the one that was used to refer to the Court of Appeal as to the first occasion. It went back to the decision of Judge Robertson back in December.
Right.
A decision was made after this ruling that the previous decision or the previous case was a better one for referral.
I see. But was there not in this case also a reference to the first occasion as well?
I'd have to look at it off the top of my head. I can't remember whether it was.
In any event, after the trial judge, in respect of the second complainant, decided that or ruled that the allegations or the charges were not sufficiently particularised, the DPP made a referral to the appeal in respect of the sufficiency of particulars in historical sexual offences.
Yes.
And the facts that were put to the Court of Criminal Appeal were founded on the allegations made against Mr Baker in the second trial. Is that right?
No, the first trial.
The first trial relating to the allegations made against Mr Baker in the second trial. Is that right? And the reason for that referral was because the issue of particulars was causing difficulties for the DPP in prosecuting matters such as the charges laid against Mr Baker.
That's right.
The Court of Appeal handed down its judgment on the 27th of February 2001. The Court of Appeal handed down its judgment or held that whether or not particulars are sufficient, in particular where a complainant says the charge occurred on the first occasion anything has ever happened between myself and the accused, depends on the circumstances of each case.
It does.
So, in effect, the Court of Criminal Appeal essentially referred to the law as it exists to this day and said whether or not particulars are sufficient will vary from case to case.
It does. So,
in terms of what you were hoping to achieve by referring the matter to the Court of Criminal Appeal, or the question of particulars to the Court of Criminal Appeal, that decision didn't assist you in prosecuting further matters or further charges against Mr Baker, did it?
Well, it clarified the law, and then we were able to review those cases in light of that ruling. So, ultimately, that's correct to say that a decision was made concerning the sufficiency of the particulars that were given by the complainants.
But in terms of considering whether the charges should proceed against Mr Baker in respect of the other 10 complainants, your position wasn't fortified in any way. It didn't give you any confidence that you could proceed on those other charges, did it?
No. Well, looking at the basis for the decision was really the basis for was the reason for the discontinuance ultimately of them.
Because ultimately, in August 2002, you discontinued the rest of the charges against Mr Baker.
That's correct.
And one of the central reasons for doing that was based on your experience in prosecuting the charges relating to the two complainants that you had prosecuted and the rulings you had obtained in those prosecutions. The DPP formed the view that those charges couldn't be sufficiently particularised to proceed to trial.
Yes, the two first instance decisions and the decision of the Court of Appeal.
And it was on that basis that on the 5th of August 2002, a nolle prosequi was entered on the remaining counts of the original indictment.
Yes, I am going from memory. There may have been a couple that may have been sufficient, but the complainants indicated they didn't wish to proceed with the prosecutions. But certainly for the majority of them, it related back to the fact that there was lack of particulars.
So by August 2002, there were no remaining charges in respect of Mr Baker. All had been the subject of a nolle prosequi.
Yes.
Now, two of the main issues that confronted you as the DPP, or confronted the DPP, in the prosecutions of Father Durham and Mr Baker was firstly the issue of particulars and secondly the issue of joinder and severance. Do you agree with that?
Yes, the decision was made fairly early on about the joinder and severance, but that was a legal issue that needed to be addressed.
I'm not saying they're the only ones, but they were two significant matters for the DPP in prosecuting Mr Baker and Father Durham.
That's right.
Can I take each in turn? In respect of particulars, after 2002, was there any legislative enactments which assisted the DPP in prosecuting child sexual offences or sexual offences which related to events that occurred many years earlier, or where there was a difficulty for the complainant to identify with any specificity the occasions when that occurred?
Prior, there was legislation introduced that related to an offence of maintaining of a sexual relationship with a child under 16. That was introduced firstly in 1989 and was amended in 2003. But in terms of historical sexual offences prior to 1989, that law had no application. It was not retrospective.
Right, so perhaps if we go to your supplementary statement, and in particular paragraph 7. So from the 3rd of July 1989, Section 229B of the Criminal Code came into effect, which created an offence of maintaining a sexual relationship with a child under 16. That's correct?
That's right.
That only related, or could only apply to offending which occurred after the 3rd of July 1989.
Correct.
So that offence couldn't be used in respect of any of the complainants or residents of Neerkol.
That's correct.
Because they alleged offences which occurred well before that.
Yes.
So in legal terms, that was not retrospective. That section was not retrospective.
So.
Now, That section proved to be not entirely effective for the DPP.
Yes, the section as it stood still required that there be a minimum of 3 acts, and then there was decisions which led to the fact that really the jury had to be agreed as to the same 3 acts, and that the actus reus of the offence provision, this is from a decision of the High Court in KBT, the actus reus of the provision as it was then drafted was that was on the offence of a sexual nature of 3 or more occasions rather than on the relationship. So as a result of that, there was amendments made in 2003.
And at paragraph 16, you set out the amendment that was made.
Yes.
And section 229B then only required proof that that one or more unlawful sexual act occurred in an unlawful sexual relationship.
That's right.
And again, that section didn't apply to any offending which occurred before the 1st of May 2003.
Correct.
So it wouldn't have been of any assistance to the residents of Neerkol.
That's right.
Or the prosecution of their charges. Since 2003, how effective has that section been in meeting some of the impediments that occur in a person providing sufficient particulars?
It has been effective. From my experience anyway, it does address that very issue, and the section that's before you there at paragraph 17 of my statement sets out the fact that a prosecution is not required to allege particulars of any unlawful sexual act that would be necessary if it were charged as a separate offence. So that directly addresses the problem that arises about the ability of the complainant to give sufficient particulars for the purpose of a prosecution for a substantive offence. So that does deal with it. I should add, though, that the offence of maintaining only can relate to where there's an element of sexual relationship. There needs to be some habituality or regularity and continuity in that relationship. So it assists for the matters such as those. But if they're isolated acts, they can't be charged as relationship. So it assists for the matters such as those. But
in respect of particulars would still apply to those isolated acts?
That's so.
If they're charged as isolated offences, not under this section?
Yes.
Can I now turn to the issue of joinder and severance?
I should add that there is still an ability, and looking at the authorities, for particulars needed to be given, but that relates to more so to the relationship rather than a particular occasion.
You would have to provide particulars of the sexual relationship or the unlawful sexual relationship in prosecuting an offence under this section.
That's so. But generally, complainants have little difficulty in identifying what the acts were. It's more linking it to a particular occasion or external event.
So those particulars can be in general terms, such as he would hug me a lot, he would massage me a lot, he would indecently touch me a lot, rather than particular occasions.
Yes, that's correct.
If I can now just turn to the issue of joinder and severance. In Queensland, the relevant sections under the Criminal Code are found at section 567 in respect of the joinder of charges and 597A in respect of the severance of charges or separate trials in respect of different charges.
Yes.
And those sections existed in 1997 to 2000 when the decision was made to proceed separately in respect of each complainant?
Yes, and from memory they're referred to in the memorandum. If this prosecution of Mr Baker and indeed Father Durham was to present itself today, on what you have read and your knowledge of the relevant both legislative provisions but also common law authorities, would you also recommend that the charges proceed separately in respect of each complainant? On the law really hasn't changed a whole lot since that time, and I'd have to say on the principles of cases such as Fennigan and De Jesus that the same decision would be made.
Now, Section 567 says that charges for more than one indictable offence can be joined if those charges are founded on the same facts or form part of a series of offences of the same or similar character or a series of offences committed for a single purpose. So that just reflects the common law, doesn't it, on joinder?
Yes, and there's little doubt that they would be joinable prima facie on an indictment.
Joinder wasn't the issue here, was it?
That's right.
The question was one of whether they should be severed. And under section 597A and B of the Code, your office formed the view that the evidence was not cross-admissible in that there was no striking similarity or underlying unity or striking similarity of system in place which could render those charges cross-admissible.
That's right, and on the basis of Fennick coming, ultimately a judge would have to reason that there's no reasonable view of the evidence which is consistent with the innocence of the accused. And
under the Queensland legislation, in making a decision for a trial judge making a decision puts to one side the issue of collusion between complainants. Isn't that correct?
That's correct. There was a High Court decision of Hock, which then was addressed by way of legislation by way of legislation isn't a relevant matter.
So the basis for the decision to agree or to proceed with separate trials in respect of each complainant was that the evidence was not cross-admissible in that there was no striking similarity or no underlying unity between the charges.
That's correct.
Can I ask you this? And your evidence is that the law is the same today in that regard on the issue of joinder and severance in Queensland. So the decision would be the same.
Yes.
Can I ask you this, and you can take this question on notice, but do you think that there is a need for legislative reform in the area of prosecuting child sexual offences or historical sexual offences, in particular in relation to both the provision of particulars and the question of joinder and severance of complainants' charges?
It's not the function of the Office of the Director of Public Prosecutions to involve itself in the policy of legal. Not the function of the Office of the Director of Public Prosecutions to, and perhaps the office could give a more considered response to that.
In writing? In
writing.
Would you also be able to consider what recommendation the Office of the DPP in Queensland would like to see from the Royal Commission in terms of what would assist in the prosecution of child sexual abuse cases? What recommendations would assist in addressing the impediments to those prosecutions?
I'd be, if it's able to be done, I will proceed on the same basis and certainly provide be in a position to provide a written response to that question.
Thank you.
Thank you.
Sir, my name is Kernigan and I act for one of the survivors who's referred to in your statement by a pseudonym, but her name is Margaret Campbell. She's also listed as counts 18, 19 and 20 in the table that you've provided with the Royal Commission. AYL is the pseudonym that will appear in your statement.
AYL.
I'd like to ask you a question just to clarify for the Commission the function of the decision of the High Court in S and the Queen, and specifically how that relates to the difficulties involved in Margaret Campbell's case. You've spoken about the issue of particularisation, and Counsellor Sisting has asked you several questions about the importance of being able to establish a notion of the first incident. You remember those questions? The first incident particularisation is just one of many different types of particularisation that any given case might take. Isn't that so?
That's correct. Obviously, that can be one of many characterisations of and there are that many variables.
Yes.
That is just but one of them.
Is it fair to say that the first incident in time is often the last port of call for want of any other more robust form of particularisation for a charge?
I wouldn't say it was the last act in a desperate attempt to find particulars. It's more if it is part of the occasion that the complainant can particularly remember, then that will be given as a particular.
Because it allows first of all, the defendant to have more clarity as to what the allegation is that he's responding to. Is that right?
Well, that was
the very point, wasn't it?
That was the point of the
very
decision
point that
in
it
Baker.
needed to be particulars outside the complainant's experience, is what I'd understood.
Do you say, just to pick up on what Her Honour has said, do you say that that is what the point of S and the Queen is?
The particularisation point is, that's what you were asking questions about.
Well, we may be at cross purposes, Your Honour. I'll approach it in this way. Is that what the Queensland Director or the Office of the Director takes to be the significance of S and the Queen?
S and the Queen was the first case. But look, the decision in Baker and picking up on what Her Honour has just said is correct, is that that's not giving an objective external fact or event or circumstances for the purposes which would assist a defendant in identifying an occasion. It's something simply that the complainant subjectively will say that was the first occasion. So it doesn't necessarily advance it much in saying that it is the first occasion.
That's right. S and the Queen, would you accept, is on a discrete point in relation to particularisation. It concerns itself with whether or not a jury can turn their mind in a unanimous way to a particular event. Would you agree with that?
Look, S and the Queen involved the issue of duplicity. It involved I think it was an incest. It involved many acts, and the difficulty with a jury being able to focus on one particular act. And I think the charge was there was only 3 charges, 1 per year for the incident. But
what I'm suggesting to you is that the issues of S and the Queen and the issues of Baker are, though connected, quite separable.
I wouldn't really agree on that.
In relation to counts 18, 19 and 20, and do you have before you the table that was provided to the Commission by your office? I'll just ask that it come up on the screen. I'm not sure of the tab number. It hasn't been tendered? I understand it can't come up on the screen, Your Honour. For the record, the page reference is, or the ringtail reference is QLD 0062 001 0355_R. This is the document that's headed Particulars RV Kevin Leslie Baker, and the file number is provided. I ask you if what is listed under the column with the heading Particulars for counts 18, 19 and 20 are, as you understand it, the particulars upon which the Crown intended to rely.
That's correct.
Is it your understanding, and I appreciate that you weren't the person making the decisions or had any conduct of the matter, but is it your understanding of the material that you've reviewed in respect to counts 18, 19 and 20 that it was considered that those particulars specified there were not sufficiently particular, giving that word its ordinary meaning, to be able to proceed to trial?
That's so. That goes back to there's a memorandum prepared by the legal practice manager in Rockhampton.
That's Mr. Mackenzie?
Yes, on the 20th of June 2002.
And you're making reference there, I take it, to the analysis of Margaret Campbell's case and whether or not it would be able to proceed. That's at point 3.4 of that memorandum.
Yes, 3.4. So the reference is the exhibit for the Commission was 0343. That document.
Thank you. The analysis of Margaret Ann Campbell's case in that report extends to 1 paragraph, and the particular observation, after noting the various strengths and facts of the case, the particular observation is that nevertheless what is fatal, and I'm quoting now, nevertheless what is fatal to the continuance of a complaint in a criminal proceeding is the lack of particularity as to when any of these incidents took place.
Yes.
the lack of particularity as to when the incidents took place is not necessarily fatal to the matter proceeding if a time frame can be provided together with other information. Is that right?
That's right. I mean, you don't have to specify a particular day, but certainly the prosecution must be able to prove and charge specific identifiable acts, and as I say, if not by date, by way of it being referred to some objective external facts, events or circumstances.
By occasion rather than date?
Yes.
For example. Do you agree with me that counts 18 and 19, as they concerned Margaret Campbell, I see it's now on the screen in front of you, at the bottom of the page, those two counts, one was an indecent dealing with a girl in circumstances of aggravation and the other was an aggravated assault, those two charges rather, are particularised as both occurring in the same incident?
That's correct.
And they're two acts of a different nature, hence the different formation of the charge?
Yes.
And you can see that the complainant recalls that those two incidents occurred when she was 12 years of age.
Yes.
And the particulars that are set out there, is it your understanding, are insufficient to ground a...
Yes.
And the particulars that are set out there, is it your... count number 20 as it was called, there is then a third incident particularised, and it's particularised here as occurring 2 years later. It's a particular incident of rape, as it's called.
Yes.
And do you, in your opinion now, exercise the view that the particulars specified there are insufficient to permit the prosecution to proceed?
No, well, sorry, my role was to review. I haven't made an independent assessment as to the sufficiency of the particulars.
Because what I want to suggest on behalf of my client is that the particulars that are set out for counts 18, 19 and 20 in fact do not fail the test for particularisation, either then or now. Is that something that you can speak to, or you don't feel you're in a position to express a view on?
So, just having a look at it, there doesn't seem to be any particular identification of the objective external facts, events or circumstances. That last count also relates the fact that there was on a number of other occasions similar things occurred.
But those were occasions that followed that event.
Yes.
And then there's a specific report of complaint evidence to Mother Amard at the age of 16. Right. Is that right?
Sorry, I don't...
Portion in bold.
I have not reviewed the evidence personally.
Can I suggest, Mr Kernaghan, it just may be more productive on behalf of your client to, if you have those instructions, to take the matter back directly to the appropriate decision maker, if they're your client's instructions, are they?
Well, they are. I was exploring the issue because some moment had been made of how the law affects these sorts of cases, and I should imagine that at some point later on in the Commission's inquiry, issues concerning the criminal justice system across the country will arise.
Definitely, which is why I'm sure Ms David made that, gave that invitation to Mr Boyle.
The difficulty, of course, for my client is
In
whether or
the
not she
very
has an opportunity at a future date to participate in such an inquiry. That's the difficulty. She wouldn't expect that she would.
No.
But in any event, I think I've taken the point as far as I can.
Thanks, Mr Kernaghan. Mr Kent, do you have any matters you wanted to raise with Mr Boyle?
I do. I'm conscious of
in the minutes left available.
And brevity is the soul of wit.
Yes, it is.
But if you indulge me, I'll attempt to do it in a few minutes.
Yes.
Mr Boyle, Learned Counsel Assisting has taken me through some of the chronology of all of this. You recall all that, correct?
Yes.
May I summarise by saying that this process started with, in respect of the accused Durham, an 18-count indictment dated the 2nd of February 1998 concerning the complaints of AYB. You agree with those propositions? And I can take you to paragraph 21 of your statement if that helps.
Sorry, are we dealing with Durham, was it?
Durham.
Durham. Yes, there was a 22-count indictment and there was an 18-count indictment.
And the 18-count indictment deals with the person with the identifier AYB.
That's correct.
Those allegations include allegations more than 37 years old at the time of drawing the indictment?
Yes.
You're aware in your practice in criminal prosecutions that historical sex charges, particularly of that kind of age, can generate stay applications at times?
They can.
And this one did?
It did.
That happened on the 24th of July 1998 and was opposed by the Crown?
Yes, that related to both indictments from memory.
And opposed successfully by the Crown, correct?
That's correct.
In October 1998, the defence applied for a change of venue.
Yes, again.
And the Crown successfully resisted that, correct?
Yes, for both indictments.
15th of February 1999, still in respect of Durham, there was a new 6-count indictment. And you're aware, are you not, of 2 sets of file notes by the trial prosecutor concerning that? I think you refer to them in your statement in paragraph 28.
So that relates to consultations with the complainant? Yes.
And if it please the Commission, these documents which previously one may not have been included but now both have identifying ringtail numbers, can I just read them? They are QLD 0062 001 0077 and QLD 0060 001 0265. I tend to those two.
36.38.
Eventually, as we've discussed, Mr Boyle, Durham pleaded guilty to the 6-count indictment. And the sentence occurred on the 15th of February 1999, correct?
Yes.
The transcript of that proceeding has the number QLD 0062 001 0082, and I tendered that.
26.39.
Mr Boyle, we've also heard, still in respect of Durham, that the Crown proceeded on count 20 of the larger indictment concerning the rape of AYP. That was an historical charge having occurred about 33 years previously.
Yes.
In May 1999, that resulted in a hung jury, correct?
Correct.
There was a retrial in September 1999. Durham was convicted and sentenced to 7.5 years imprisonment, correct?
Yes.
And it was on appeal, as we've heard, that was set aside. And if it pleases the Commission, the judgment of the Court of Appeal 2000 QCA 88 is at tender bundle 277.
Yes.
Mr Boyle, after that happened and a retrial was ordered, the Mental Health Tribunal and later the Mental Health Court ordered that Durham was unfit for trial for further proceedings, correct?
Yes, and ultimately that was determined to be unfit for trial. His unfitness for trial was of a permanent nature.
And in both of those proceedings, the Crown appeared and were represented to represent the Crown's interests, correct?
Yes.
Dealing quickly with Baker, we've heard something of the events unfolding in relation to the prosecution of Baker. There was a memorandum done in March 1999 about severance of complainants at Tender Bundle 244. I've discussed with our learned friend, Counsel Assisting, the fact that electronically at least 244 only includes the first page of that memo, and I think arrangements are being made for the rest of the memo to be... That's been done, right? We've also been through, Mr Boyle, in the evidence this afternoon, the 10-count indictment, which was then produced concerning AYR's complaints, resulted in one trial where there was directed verdicts, acquittals and a hung jury for 4 counts, correct?
Yes.
Then a new 4-count indictment produced, and that case again prosecuted, correct?
Yes.
Mistrial in August 1999 because of a juror being on both juries.
Yes.
Retrial again in December 1999, resulting in the ruling by Judge Robertson, in turn leading to the reference by the Attorney-General to the Court of Appeal and the decision in RV Baker that we've heard about, correct?
So that was ultimately done with respect to that decision down the track.
That's right. In the meantime, there was another attempt to prosecute Baker in respect of a 6-count indictment concerning another male complainant, resulting in a similar ruling to that of Judge Robertson's made by His Honour Judge Nace, correct?
Yes.
And following all of that, there was another prosecution of Baker concerning assault occasionally bodily harm in August 2001, correct?
Yes.
Hung jury.
Correct.
And then that male complainant did not wish to proceed again with the next trial. From your review of all of this and our little discussion about it over the last few minutes, can you think of anything else the Crown could have reasonably done to attempt to bring these prosecutions to a satisfactory conclusion?
No.
May I touch briefly on the subject of the... Just before I finally pass from that chapter, could I just ask that we put on the screen Tender Bundle 3, tab 318. You're familiar with this correspondence, Mr Boyle. This is the letter written by Mr McKenzie in July 2002?
Yes.
It is the letter to AYL's solicitors setting out the attempts to contact her directly and the explanation for the officer's then actions concerning any further prosecution. Is that correct?
That's correct.
Thank you. As has been touched on, you gave a supplementary statement about broadly any law reform since all of this unfolded. And you've taken us to, or you've been discussed with you, section 597 capital A of the Criminal Code, and particularly subsection 1 capital A, dealing with the legislative repeal of Hock's case, correct?
Yes, and I think there was also a section of the Evidence Act that...
So that's section 132 capital A, and you refer to that as well, don't you?
Sorry, I don't. Yes, I do, but it's not referred to in any statement.
No. In our discussions, perhaps you're referring to. So I might just distribute that. I don't think it's necessary to tend to legislative provisions, but I might just distribute it to the parties. And Mr Boyle, you've also had a look at the definitive text on criminal law in Queensland, Carter's Criminal Law, and you have extracted the relevant sections about section 597 capital A and the legislative, the case law interpreting that. You've done that as well?
Yes.
So we'll distribute that as well. We'll seek to refer to that in submissions. Just finally, Mr Boyle, I think you were cross-examined by Mr Kernaghan a little while ago about the level of particularities set out in the schedule for counts 18 to 20. You may recall, and I think what I'm suggesting to you is a passage possibly from Baker itself in Court of Appeal, but is one of the problems with particularity that it's not really helpful to set out particulars that assume guilt of the count. You recall that concept? If all the particulars are posited on the basis that the accused is guilty of the count and therefore it should mean something to him, that's often held not to be sufficient particulars. Is that right?
Yes, it has to be something more objective.
Thank you. Nothing further, if it please the Commissioner.
Thanks, Mr Kent.
Commissioner, I did stand before, but I don't think you saw me. I have one brief matter that I'd like to ask Mr Boyle about.
On behalf of one of your clients?
Yes, on behalf of AYB.
Go on, Ms McClinch.
Mr Boyle, I appear for AYB in these proceedings.
Right.
AYB was a complainant in the prosecution of Mr Durham, as you are aware.
Yes.
She gave her evidence, as did the other witnesses, in a closed court. Are you aware of that?
At a committal proceeding?
Yes.
Yes. Well, I'm aware that all complainants did give evidence in a committal proceeding, and that would have been a closed court, yes.
Can you think of any circumstance where it would be acceptable for a transcript of her evidence to be provided to a third party, particularly where she wasn't consulted?
A transcript of a complainant's evidence?
Yes.
I can't think of an occasion.
Can you be more specific, Ms McClinch? You don't need to name the third party, but what
Yes.
sort of, what was the role? Was it an insurance company or a solicitor?
I'm sorry. Yeah, a separate complainant, nothing to do with this particular case. I can be a little bit more specific.
I'd have to agree that most definitely it shouldn't be given to another complainant because of the problems of it being somehow influential on that complainant's evidence. So, I mean, there are occasions where transcripts should be disclosed for various reasons to different parties who need it, but that certainly wouldn't fall into that category.
Is it, would the fact that the evidence was given in a closed court have any effect on that decision, whether a transcript should be provided or not?
Off the top of my head, I can't imagine. And I think under the current law, it probably wouldn't even be lawful to give that. But I mean, I'd have to double check that. But
In your examination of the files in preparation of your evidence today, did you come across a complaint made by AYB that evidence from her proceedings was provided to another person?
I vaguely remember seeing that amongst the correspondence, yes.
Did you examine that in any way and find any justification for it?
I didn't make any assessment. I don't know the circumstances for which who disclosed it. I don't know.
Ms. McLeish, that's not a matter that can be properly resolved or
I've certainly
litigated.
taken it as far as I can. Thank you.
Thank you.
Thank you, Mr. Boyle.
There's nothing arising, Your Honour.
Thank you, Mr. Boyle. Thank you for your attendance at the Royal Commission. You're excused.
Sorry to interrupt. Can I have a word with Councillor Sisting?
There's just some documents to tender, Your Honour. Firstly, in respect of this witness's evidence, can I tender a chart of particulars referred to in the evidence with the doc ID number of Queensland QLD 0062 001 0351R, labelled particulars, the Queen and Kevin Baker.
26.40.
Can I also tender a document dated memorandum of the Office of the Director of Public Prosecutions, dated the 20th of June 2002. In respect of this document, can I note that in paragraph 3.10 there's a redacted name. That person is not a witness in these proceedings and is not Margaret Campbell.
Thank you. 26.41.
Can I now tender two statements? Firstly, the statement of Mrs. Kate Pope, dated the 30th of March 2015.
26.42.
And the statement of Bishop Michael McCarthy, dated the 10th of April 2015.
26.43.
Attached to the latter of those statements are two documents, which I tender as one. A message to the people of the Diocese of Rockhampton, dated the 30th of January 2015, and a second message to the people, dated the 9th of April 2015.
26.44.
And finally, Your Honour, can I provide a direction in respect of submissions, that Council assisting submissions be completed or provided in writing by Friday the 22nd of May of this year, that any written submissions in reply be provided within 4 weeks of that date, and any further written submissions in reply provided within 2 weeks of the day that the earlier submissions are provided. It's in a formal written direction, but I just
Thank you.
say it orally for everyone's benefit.
I will make that direction with respect to closing written submissions. Thank you.
Your Honour, that's all the material and evidence to be placed before the public hearing.
Thank you.
So,
yes.
I understand Mr Kernaghan's just indicated he has one final matter to raise.
Your Honour, a matter's been raised to me in regards to the exhibit that was just tendered, paragraph 3.10 of the memorandum to the Director of Public Prosecutions, about whether or not the redacted name, it was suggested in my cross-examination of Ms Rowan, whether or not I was intimating that the redacted name was my client, Margaret Campbell. I understand it's a source of some concern to those that instruct Ms Needham. The relevant transcript reference is page 8061. I have not made that suggestion to Ms Rowan. I don't make that suggestion. It is in the terms, what I put to Ms Rowan is in the same terms as what's in the document, that a complainant, who it appears from the face of the document is male, had some representation via a member of the Sisters of Mercy. I put that as part of my client's interest to understand the circumstances in which contact was made by the DPP with complainants that they could not apparently contact, and my client is one of those people. But I wasn't suggesting anything other, and I don't think a fair reading of the transcript would suggest that I was, but for abundant caution.
In any event, it's corrected. Thank you. So I hope that those who've been watching these proceedings understand now, Ms David, that that's the close of the evidence in this public hearing, and that the next stages of the public hearing will be by way now of the exchange, first the provision of written submissions by you as counsel assisting the Commission, and then exchange of written submissions by the other interested parties.
And we'll provide the specific dates in writing so everybody's got
so everyone's able to follow that, and that once that all of that submission process is completed, that those submissions will be published in the usual way.
Yes, so they're accessible by all.
Thank you. And then following that, it may or may not be that there's an opportunity provided for oral submissions before the Commission makes its final report. But for anyone following these proceedings, if they're unclear about any of that process, I'm sure the Commission staff will assist them.
Thank you.
So otherwise, on the awaiting those next steps from the Commission, will otherwise adjourn. Thank you.
Silence will stand.